All right, buckle up everybody, because today's courtroom session, absolute chaos disguised as procedure. We've got Judge Middleton on the bench, cool, calm, sharp as a tack, handling two cases that go in completely opposite directions. And honestly, one of them might be the wildest plea hearing I've ever broken down. Picture this. A woman walks into court, ready to plead guilty to domestic violence. She's got a deal. Good deal, actually. Do some probation, charge disappears from her public record, life moves on. Simple, right? All she has to do is tell the judge what happened. Easy. Except, and this is where it gets absolutely unreal, she starts describing the incident, and her own story starts sounding less like I committed a crime and more like I was a terrified mother protecting her children from a drunk, raging man twice her size who once choked his ex-wife. Yeah, you heard that right. The judge is sitting there listening, and you can practically see the gears turning in his head going, "Ma'am, I think you just described self-defense." The plea? Dead on arrival. Gone. The judge literally cannot accept it. And then, because one wild case isn't enough, we get a second one. A woman who hit a 5-year-old child with her car, watched the kid get helped by a bystander, and then just drove away. Didn't call 911, didn't file a report, just left, because she was scared. The child ended up in the hospital covered in bruises and cuts, and it was witnesses, not the driver, who brought it to the attention of police. Two women, two very different situations. One judge making sure the system actually works the way it's supposed to. Trust me, you don't want to skip a second of this. Let's go.
Ms. O'Mara?
That's my understanding, Mr. Lawyer.
Ms. Baton, have you heard what the attorneys have said the resolution of this case is?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes, Your Honor.
Please raise your right hand. You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
It's my understanding that you'll be pleading guilty essentially as charged to count number 1 of domestic violence, which is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Now, you have a sentence agreement with the prosecutor that I would sentence you under 4A, which is a reference to the statute. But what that essentially says is that I would put you on a period of probation. And as long as you're successful with that probation, this charge would not show on your public record. It would show on your law enforcement record and your court record. So we would be able to see it, but anybody running your public record would not. Do you understand that?
Yes, Your Honor.
Now, do you also understand that that is an agreement you have with the prosecutor? That's not an agreement you have with me. So if I decided that I was not going to follow that agreement, you would be able to withdraw your plea and we'd come back here and start over again. Do you understand that?
Yes, Your Honor.
Knowing all that, then, do you still wish to?
Okay, quick timeout. Let me translate what just happened because the judge dropped some serious legal lingo and I don't want anyone getting lost. That 4A he's talking about, that's Michigan Statute 769.4A. And it's basically the legal system's version of a second chance card. You plead guilty, you behave on probation, and poof, the charge vanishes from your public record. Your boss can't see it, your landlord can't see it. It's like it never happened. Well, almost. Cops and courts can still see it. So it's not a magic eraser, more like a really good filter. But here's the part most people miss, and the judge made sure to spell it out. This deal is between Baton and the prosecutor. The judge doesn't owe her anything. If he decides the deal doesn't sit right, he can toss it, and she gets to start over from scratch. He's basically saying, I'm the referee here, not a party to your agreement. And spoiler alert, that distinction is about to matter way more than anyone in that courtroom expected. Keep watching.
Enter the plea today?
Yes, Your Honor.
Back on June 21st of this year, were you on probation or parole?
No, Your Honor.
Were you on bond?
No, Your Honor.
Do you remember reading and signing this advice of rights form? Talk about your rights to an attorney and your rights to a trial.
Yes, Your Honor.
Did you understand those rights?
Yes.
Most importantly, do you understand that you have a right to have a trial, and by entering a guilty plea today, you'll be giving up that right. You won't have a trial of any kind.
Yes, Your Honor.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
And is it your own free choice to plead?
Yes, Your Honor.
Are counsel aware of any of their promises, threats, or inducements not made part of the record?
No.
No, Your Honor.
Then, Ms. Baton, to the allegation that on or about July 21st, 2025, I said June 21st, 2025, in Cedar Creek Township of Wexford County, how do you plead to domestic violence?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on that date, were you in Cedar Creek Township?
I was.
And did you have some sort of relationship with a Nicholas Carsons?
I did.
What was that relationship?
We were boyfriend and girlfriend.
Were you at that time?
Yes, we were at that time. We are no longer boyfriend and girlfriend. We
All
were
right.
at that time.
And what happened that night? What did you do?
It was in the morning, 8:30 in the morning.
Sorry.
He had been drinking, and we were going through a separation. I was trying to move out of the house. I was moving some of my things. He had his own vehicle. I had my own vehicle. He grabbed my keys and walked out of our sliding glass door. I went after him and grabbed my keys back from him. He followed me back into the sliding glass door. I put my hand up like this onto his chest and pushed him.
Whoa, 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 hold up. Did she just accidentally torpedo her own guilty plea? Let's rewind what she said because I need y'all to hear this. It's 8:30 in the morning. The man has been drinking. At 8:30 a.m., by the way, which is a whole separate conversation. They're splitting up. She's trying to get her stuff and leave peacefully. And what does he do? Grabs her car keys and walks off with them. She's a single mom of 3. Those kids are right there in the house. Her keys are her lifeline. That's her way out. So she grabs her keys back. Totally reasonable. And then he follows her back inside through the sliding glass door. She pushes him. She slaps him. He calls the cops. Now look, she's in court trying to plead guilty. She's doing what her lawyers told her to do. But every single word coming out of her mouth screams, I was reacting, not attacking. She's not describing a crime. She's describing survival instincts kicking in. And the beautiful thing is, the judge is catching every word of it. He hasn't said anything yet, but you can tell something isn't adding up for him. Just wait.
Backwards, and then I slapped him in the face, and then he called the cops.
And why did you do that?
Because he was advancing towards me, coming in the door, and I just wanted him to stay out of the door. I told him to leave, get your own keys and leave. Since you've been drinking, you can take your own vehicle and leave, but I don't need you taking mine. I'm a single mom of 3 kids. They were all there. I didn't want him to continue to go towards my kids. So I put my hand up, I slapped him in the face. I said, back up, go away. And he walked outside and said, I'll make you pay for this, and called the cops.
And when you did that, what was
Yes.
going through your mind?
I was afraid that he was gonna come after me or my kids. He had a previous personal protection order against his ex-wife. So I just wanted him to stop. I wasn't trying to physically hurt him. I wanted him to stop advancing towards me and my children.
And what was his demeanor like when you did that?
I feel like just wanted me to get in trouble. I think he wanted me to do something so that he would make me go to jail, honestly.
Was he acting in a certain way or saying
I think
something?
he was very red-faced, very angry. He normally has an alcohol issue, so it's not out of character for me to see him like this, but
When you say he was very angry, can you describe that some more? For me?
bloodshot eyes, just veins popping out of his arms. I mean, he's 6'4", I'm 5'3", he weighs 250 pounds.
Was he saying anything?
I'm gonna make you pay for this.
That was before or after you?
He said it twice, before and after. As he was coming in the door and my hand was on him, he said, I'm gonna make you pay for this. So I slapped him, and then he said,
I'm going to make you pay for this. He said that before she laid a finger on him. Let that marinate for a second. 6'4", 250, bloodshot eyes, veins bulging, drunk at 8:30 in the morning, chest puffed out, storming through the door toward a woman who's 5'3" and maybe a $120 soaking wet, with 3 kids behind her. And he said, I'm going to make you pay. And then after she slapped him, he upgraded it. I'm definitely going to make you pay for that. And then, here's the kicker, he didn't swing. He didn't push back. He walked outside and called the police. Think about that. He didn't call the cops because he was hurt. Let's be real. A slap from a 5'3" woman did not injure this man. He called the cops because, in her own words, he wanted me to get in trouble. That's not a victim reporting a crime. That's someone weaponizing the legal system. And she saw it coming. She literally told the judge, I think he wanted me to do something so he could make me go to jail. You know what? I've seen a lot of courtroom cases, but when the so-called victim is a 250-pound man with a history of choking women, and the defendant is a terrified mom trying to keep her kids safe, the labels start to feel real backwards. What do you think? Let me know in the comments, because this one's got people divided.
I'm gonna make you pay for that.
Now, you had said something along the lines, and I can't remember your exact words, but you were essentially sounded like you had some fear as to what might happen.
Yeah,
Can you describe that some more for me?
I just didn't want my kids to get hurt or him to do anything to me when he was going through his divorce, his previous divorce. He choked his ex-wife. That's why she had personal protection orders against him. I was afraid that he was going to do something like that to me. And
Did he make any outward motions or say anything that made you think that that would happen?
just walking very fast and briskly towards me and continue, like I said, he's 6'4", 250 pounds. When you're coming at me, like with your chest pushed out, it kind of just, like I said, scared me. And I just wanted to get him away from me. I wasn't trying to physically, obviously I can't physically hurt him. He's way bigger than I am, but I just wanted him to get back away from where I was and where my children were.
Okay. Counsel, I don't believe I can accept that plea. You want some more time to regroup on this? I'm willing to set it over for a status conference.
Boom, there it is. 7 words that changed this entire case. I don't believe I can accept that. Judge Middleton just pulled the emergency brake on this plea. And honestly, I had a feeling this was coming the second she started talking about being afraid. Here's the thing people don't realize about guilty pleas. The judge isn't just sitting there nodding along like a bobblehead. He has a legal obligation to make sure the defendant's own words actually describe the crime they're pleading to. It's called establishing a factual basis. And domestic violence requires an assault, not a defensive reaction to a credible threat. Everything Baton described? Fear, a man twice her size advancing aggressively, a known history of violence, kids in the home, verbal threats, her pushing him away and slapping him to create distance. That's textbook self-defense, folks. The judge can't just ignore that. If he accepted this plea knowing her story sounds like a legal defense, he'd be doing her a disservice. He'd essentially be letting a potentially innocent woman convict herself. So he does the right thing. He stops the whole process cold and offers to give everyone time to figure it out. That's not a technicality. That's a judge actually protecting someone's rights. We don't see that enough.
Next week, if you want to do that.
I'm fine with the people. No, absolutely not.
I would rather be set for trial.
All right. So, Ms. Baton, so it's through no fault of your own. You've done nothing wrong. You've told me as you perceived the events that night. It's just that based on what you've told me, I'm not able to accept that plea.
Okay.
So, what your attorney is requesting that we do then is to set the matter for a trial.
Okay.
At that trial, the prosecution would have to prove your guilt beyond a reasonable doubt.
And that's what they told me. And I mean, I did slap him in the face. And so that's
Well,
what they said.
so, I mean, I can't give legal advice at all,
Right.
but the way you've expressed it to me, it's possible that there's a defense there. And that would be up to the jury to.
Can we just appreciate what the judge did right there? Because it was absolutely surgical. Miss Baton is standing there saying, but I did slap him. Like she genuinely believes that one slap automatically makes her guilty. Case closed, no discussion. And the judge, without crossing the line into giving legal advice because he can't do that, basically looks at her and says, it's possible there's a defense there. Possible. Defense. There. That's judge speak for, ma'am, you might want to rethink this whole thing. He even tells her it would be up to a jury to decide. Not him, a jury. And what does that tell you? It tells you the judge thinks this case has enough gray area that 12 regular people need to hear it. He's not saying she's innocent. He's not saying she's guilty. He's saying her story deserves more than a checkbox in a plea deal. And you know what's wild? If a less attentive judge had been on that bench, someone just trying to clear the docket before lunch, they might have accepted the plea, slapped probation on her, and moved on. Baton would have walked away with a domestic violence conviction without ever knowing she might have had a real shot at acquittal. That's why these moments matter. The system worked today because one judge actually listened.
Determine whether or not me, but that's up to the jury to determine whether or not that's an applicable defense.
And that was.
And so it looks like we'll be setting the matter for a trial.
That's fine.
Ms. Carey, are you aware of any issues for trial?
Yeah.
Ms. O'Mara, are you aware of any issues for trial?
I don't. So I know Nicholas Carson is a former client of ours. I don't know if he's, no, I don't see an issue. I just wanted to mention that someone applied to the public defender's office.
Ms. Carey, I know Ms. Baton has mentioned some possible 404 things. Were you aware of those before today?
Not today, because I didn't look at me today.
Do you anticipate any 404 filings?
I can give you her name.
That's not up to you. Oh, wait, I'm sorry. No, that would not be up to you. That'd be up to, okay. Sorry. All right. So we are, today's final pre-trials are being scheduled for October 17th, and I believe this is the only trial we've got so far. So the court will go ahead and we will schedule this for trial on the 17th of October. If something happens between now and then, I will take a plea in this case, just because of the situation that it is. So I will take a plea if the parties decide that they work around any issues that we have. So we will set this for trial. Just making some notes. Ms. O'Mara, you mentioned that your office had previously represented the alleged victim in this case. Do you believe there's anything that in that representation that rises to a level of a conflict?
Not from my personal experience or it's not a conflict for me. I don't know that it would be a conflict for someone else in the office.
I'm seeing Mr. Harrison shake his head and Ms. Firavento shaking her head as well. So I'll take that as of right now, we're not anticipating a conflict.
I'm not knowing the details in general, Your Honor. If there is a prior file that is now closed and it's unrelated to the prior file in any way, our office does not consider that a conflict. It is only if there's a current open file, such as he was a defendant in another case, then it would be a conflict.
Or if anything learned in that representation would be used against him in this case.
We don't believe that to be a realistic possibility.
All right. So as of right now, the court will treat it as if there is no conflict, but certainly if the parties discover a conflict, I'm going to request that be brought to the court immediately so we can look into that. Okay. Ms. Baton, just a reminder that your bond conditions continue. You can go out to the front window where you checked in and get your next court date, which will be the trial date.
Okay, thank
All
you,
right.
Your Honor.
Make sure you stay.
All right, so case 1 is heading to trial. October 17th, mark your calendars. But before we move on, let me quickly explain the two big legal things that just flew by. First, the conflict of interest. Turns out the public defender's office previously represented Nicholas Carson, the alleged victim. Yeah, the same guy Baton says choked his ex-wife. Now they're defending the woman accused of assaulting him. That's awkward, to say the least. The office says the old case is closed and unrelated, so no conflict. For now, the judge accepts that, but makes it clear. If a conflict pops up later, he wants to know immediately. No surprises. Second thing, 404 filings. That's Michigan Rule of Evidence 404B, and this is where it gets juicy. It's about whether prior bad acts can be brought up at trial. If the defense files a 404B motion and wins, Carson's history, the choking, the protection orders, could be presented to the jury. Imagine being a juror and hearing that the victim in this domestic violence case has a history of strangling women. That changes everything. This trial could be a big deal. But right now, we've got a whole second case to get through, and folks, this one's a gut punch. Different energy entirely. Let's get into it.
In touch with your attorney.
Thank you.
This is case number 253336 ST, appearances counsel.
Joanna Carey for the people.
Even O'Mara on behalf of Ms. Nash.
And we are here for a final pretrial conference. Is there any resolution?
Yes, Your Honor. My client is to plead no contest to as charged.
Ms. Carey? And the purpose for the no contest plea?
Civil liability.
Is there a restitution requested in this case?
There isn't restitution requested, but the victim would be a child who was struck. So we just want to, in case that comes up in a civil matter, as a civil.
No, it's not a victim notification case. So whether there's restitution or not, I think the child was taken to the hospital. I'm not sure there was injury. I think it would be checked out. We didn't report it, so.
I have the report.
The defense said, I gave them my report.
So, yeah, is it marked already? So just so I'm clear, there was a victim from the accident was taken to the hospital for medical. We just don't know whether there's restitution. All right. Ms. Nash, have you heard what the attorneys have said the resolution in this case is?
Yes, sir.
And is that how you wish to resolve it?
Yes, sir.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may put your hand down. It's my understanding that you'll be pleading no contest to the charged offense of failed to report an accident. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $100. Is that your understanding of the?
Okay, so if case 1 was an emotional roller coaster, case 2 is a chess match, and the opening move, a no contest plea. Let me break this down because it's one of the slickest legal maneuvers in the playbook. When you plead guilty, you're standing up and saying, yep, I did it, that's on me. When you plead no contest, you're saying, I'm not going to fight this, but I'm also not admitting I did anything wrong. The court treats it the same way for sentencing. Guilty is guilty either way. But here's the genius part. If the victim's family later files a civil lawsuit, and when a 5-year-old gets hit by a car, there's a decent chance that's happening, a guilty plea can be used against you in that civil case like a flashing neon sign that says, I admitted fault. A no contest plea? Way harder to use. It's basically a legal shield for the civil battle that might be coming. The attorney said 2 words when the judge asked why no contest. Civil liability. Short, sweet, strategic. That's a lawyer who's playing 3 moves ahead. Smart? Absolutely. But when the victim is a kindergartner who ended up in a hospital, smart and satisfying aren't always the same thing.
Plea agreement?
Yes, sir.
Now, a no contest plea is a plea that essentially means that you are accepting guilt without saying that you're guilty. And there's only certain reasons a court can take that. And in this case, I'm being told that from the attorneys that it's potential civil liability because there was some injury or possible injury in this case that you might be responsible for reimbursements for. And so in order to accept the plea, the court would then be reviewing a document. In this case, it looks like it's going to be a police report to determine whether or not there is enough evidence to support the plea and to find you guilty and for sentencing purposes. Do you understand that? Yes.
Yes.
All right. Yeah. All right. Back on May 22nd of this year, were you on probation or parole?
What was that?
Were you on probation or parole back in May?
No,
Were you on bond?
yes. Because of the situation. From what I-
So when the event happened, you weren't on bond, is that
No.
correct?
No.
All right. Do you remember reading and signing this advice and rights form? It talked about your rights to an attorney and your rights to a trial.
Yes, sir.
Did you understand those rights? Most importantly, do you understand that you have a right to have a trial, and by entering a no contest plea today, you'll be giving up that right and you won't have a trial of any kind? Yes? Knowing that, then, do you still wish to enter the no contest plea?
I'm sorry.
Do you still wish to enter the no contest plea?
Yes,
Other than the, well, I guess we don't have an agreement. Has anybody promised you anything in order to get you to plea?
no, sir.
Has anybody threatened you in any way?
No,
And is it your own free choice to plea today?
yes.
Then to the allegation, I'm sorry, counsel, are either of you aware of any other promises, threats, or inducements not made part of the record?
No.
No, you're not.
Then Ms. Nash, the allegation that on or about May 22nd, 2025 in the city of Cadillac, how do you plead to fail to report an accident? I
Plead
anticipate
guilty, sir.
to be a no contest
I'll
plea.
say, no, that's sorry.
All right. Counsel, I've been provided with what's been marked as People's Exhibit number 1, which is a Cadillac Police Department report, incident number 25-001354. Ms. Carey, are you moving for a submission?
And
Ms. O'Mara, any objection?
No objection.
All right, give me, People's 1 is received. Give me All right, counsel, I've had the opportunity to review People's Exhibit number 1. Do you believe it provides a factual basis in which to accept the plea and that the court rules have been complied with?
I do.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Nash, I find you guilty of failing to report an accident. In particular, People's Exhibit number 1 makes out that in the city of Cadillac on Lake Street, on May 22nd of this year, there was an incident in which I believe correctly, five-year-old boy had run across the street from behind a pickup and was struck by a vehicle driven by Ms. Nash. Ms. Nash, through some investigation, was identified and interviewed by law enforcement, where she admitted to striking the child, admits that she didn't see him until the last minute because he ran behind the pickup truck going in the opposite direction. And she did assume the man that was assisting the boy was the father, but he never spoke with her. She eventually leaves the scene because the father would not speak to her and that she was scared. The other witnesses reported that the boy had bruising and had been cut up and had blood. This came to the attention of law enforcement while...
Man, this one's tough. A 5-year-old kid darts out from behind a parked pickup truck into the street and gets hit. Bruised, cut up, bleeding, ends up in the hospital. That alone is devastating enough. But then you hear the rest of it. Nash stopped. She saw someone helping the boy. She assumed it was his dad. The man didn't talk to her, and so she just left. She drove away from a child she'd just struck with her car because the bystander wouldn't make eye contact and she got scared. I get it, panic is real. Your brain goes haywire in moments like that. But here's the thing, you just hit a kindergartner, a little boy who's now bleeding on the sidewalk. Scared isn't a reason to leave, it's a reason to stay. Call 911, flag someone down, do something, anything. The fact that police had to track her down through an investigation while this kid was getting treated at the hospital, that's the part that stings. It wasn't Nash who reported the accident, it was witnesses. The child's injuries brought the cops, not the driver's conscience. And look, maybe the accident itself was unavoidable. Kids are unpredictable. Pickup trucks block your view. I get all of that. But the charge isn't hitting a child. The charge is failing to report it. And that part, that was entirely her choice. What would you have done? Honestly, sit with that for a second.
The victim was at the Munson Hospital for treatment. As such, I find there is a factual basis to accept the plea. Additionally, I find the interests of justice are well served in allowing the defendant to enter a no contest plea to avoid any potential civil liability that may arise out of this case. Ms. Carey, is there any victim input?
There isn't, as I said,
Oh, there is no victim rights were given. I am going to, on my own, adjourn today for sentencing. Ms. Carey, I know this is not a crime victims' rights case, but I think in this type of case, I think it would be appropriate to at least reach out to them to see whether or not there's anything that they would like the court to know. I'm also going to order a PSI in this case. So we will set this out for 2 weeks. Ms. Nash, just a reminder that your bond conditions continue. You can go out to the front window where you checked in and get your next court date. Okay, thank you.
Your Honor, I know pre-sentence investigation reports are typically...
All right, everybody, that's going to do it for today's breakdown. But before you click away, I seriously want to hear from you on this one. Do you think Miss Baton has a real shot at trial with a self-defense argument? And what about Miss Nash? Should failing to report an accident involving a child carry a stiffer penalty than 90 days max? The comment section is wide open, and I read every single one, so don't be shy. If this video had you glued to the screen, and let's be honest, that Baton case had all of us leaning leaning in, do me a huge favor and smash that like button. It takes half a second and it helps more people discover these breakdowns. Share this with a friend who loves courtroom drama or legal deep dives. You know they'll thank you for it. And if you're not subscribed yet, what are you even doing? Hit subscribe, turn on that bell notification, and join the family so you never miss another jaw-dropping courtroom moment. We've got more cases coming that are going to blow your mind. I'll see you in the next one. Stay sharp out there.